May it please the court, my name is Ezekiel Lugo and I represent the Appellant, State Farm, Florida Insurance Company. At this point, I would like to reserve 5 minutes for rebuttal, Judge Kazam.
So you won below and got stuck with fees.
Exactly, Judge Morris.
How does that happen?
How does that happen? That happens because the plaintiff's attorney convinced the trial court that the only thing that mattered as to appellate attorney's fees was this court's fee order in the 2009 appeal. And that's wrong, and it's wrong for two reasons. The first reason it's wrong is that what directed the proceedings on remand was the mandate that this court issued at the end of the 2009 appeal. And that mandate says clearly and explicitly that further proceedings have to be conducted in compliance with the court's opinion and in compliance with Florida law. And that leads me to the second reason why it's wrong, and that's that Florida law, the only basis asserted in this case for appellate attorney's fees or any kind of attorney's fees was section 627.428. And under that statute and the case law interpreting that statute, not only does the policyholder have to prevail on appeal, but the policyholder also has to ultimately prevail on remand. And Judge Morris, you hit it right in the head. You know, we won in the trial court and then somehow we get stuck with appellate attorney's fees. There is a disconnect there. Now, turning to its first point, dealing with the mandate, the wording in the mandate couldn't be more clear. Trial court, you have to conduct further proceedings in accordance with the opinion in Florida law. The opinion states that, and sets the standard for 627.428. You know, an insurer's post-suit payment of additional policy proceeds entitles the insurer to section 627.428 attorney fees where the insurer wrongfully caused its insured to resort to litigation. This court remanded the case for a factual determination to see if that standard had been met. And this court said we must reverse because there's material questions of fact as to whether the Beverleys were forced to file suit to resolve the claim under the insurance policy. The trial court was required to look not just at the fee order, but to that opinion and to that specific language setting forth the standard under section 627.428 and the factual determination that was required. And once the trial court found that the Beverleys were not forced to file suit and found that they were not entitled to fees, in accordance with those findings, it should have also found that they were not entitled to appellate attorney's fees. And in the trial court, in the appellate fee portion of the proceedings, State Farm argued the case of Allstate versus De La Fe. And that is a case where a similar situation happened. It was also about attorney's fees under 627.428. It was a situation where the policyholder's complaint had been dismissed. There was an appeal taken. The insurance company confessed judgment. And the third DCA entered a fee order directing the trial court to fix the amount of fees and remanded the case back to the trial court for further proceedings. When it went back on the further proceedings before the case had ended, the trial court awarded appellate attorney's fees. The insurance company appealed that order, and on appeal, the third DCA said, well, we just need to clarify what we meant. You know, it's obvious that what we meant was that the policyholders would be entitled to appellate attorney's fees if they ultimately prevailed on remand. The case hasn't been decided on remand. We don't know yet. So the only way policyholders, you can be entitled to attorney's fees is if you prevail. Now, this court has followed a very similar position, and there's a case called Sabina versus Dahlia Corporation in 1996. It's an attorney fees case, does not involve 627.428, but it goes along with the general proposition that when there is an interlocutory appeal and there's going to be further proceedings on remand, the policyholder, or sorry, the party seeking attorney's fees not only has to prevail on appeal, but also at the end of the proceedings on remand. And in the Sabina case, at the end of the proceedings, the party seeking attorney's fees lost. So this court, when the party against whom the fees have been assessed, argued to this court, well, you know, it has to be clarified. You need to enforce the mandate, and this court did so. I know opposing counsel in his brief is claiming that what we're trying to do is recall the mandate and alter the mandate and change what this court did before.
That's why I wanted to clarify that, if you could address that, Mr.
But that's not what we're asking the court to do. We're asking the court to do exactly what happened in Allstate versus De La Fe and what happened in the Sabina case. And we cited another case as a first DCA case, Department of Transportation versus Bernetti, where the first DCA explained that, if the trial court has been confused or led astray as to what was meant by the prior decision of the court, the appellate court has the power to clarify its prior ruling and to direct the trial court to comply with what the appellate court intended to be done in the first appeal. That is what we're asking in this case, merely to clarify that the fee order in the prior case had to be considered in light of the opinion that had been issued, which is what the mandate says. If that was done, the trial court should have denied the motion for appellate attorney's fees. Now, turning to the second reason why there's error, that it's based on the plain language of section 627.428. That statute, it's in derogation of the common law. It has to be strictly construed. And there's two portions that are relevant to this case. Is the very first clause, upon the rendition of a judgment or decree. The second section is the very last clause, which talks about prosecuting the suit in which the recovery is had. In between those two clauses is the reference to appellate attorney's fees. It's sandwiched in between the two. Florida courts, going back to the 1970s, have interpreted the statute to mean that not only does the policyholder have to prevail on appeal, but the policyholder also has to prevail on remand. Now, in this court's prior opinion, as co-counsel mentioned, there was reference to Goff, Clifton, and Hill. And those cases, at least in Clifton and Hill, this court remanded for further proceedings to determine whether the policyholder had been forced to file suit. In both of those cases, we filed a notice of supplemental authority, including the fee orders in those cases, and the fee orders in those two cases were contingent on the policyholder prevailing ultimately at the end of the case. And the Clifton fee order cites a case out of the 3rd DCA, Professional Medical Group versus United Auto. The very last sentence of that case talks about the De La Fe case that State Farm raised in the trial court and is raising on appeal. And it says, fees should have been awarded conditioned upon the insured ultimately prevailing with the recovery on the policy. See Allstate versus De La Fe. Those fee orders were directed to opposing counsel. Opposing counsel knew what had happened in Clifton and Hill, and I'm sure he's aware of the general requirement of their 627.428 that there has to be prevailing in the appellate court and prevailing on remand, and that simply didn't happen here. And there was a notice of supplemental authority filed by opposing counsel about the Hamilton case out of the 5th DCA, and there's 3 things attached to that notice of supplemental authority. The first thing is the opinion of the court in that case, which does not talk about appellate attorney's fees. It does remand the case for further proceedings. The second thing included there is a fee order, which grants the policyholder's motion for appellate attorney's fees and remands it for the circuit court to assess the reasonable amount. We don't know what the motion or the motion that led to this order is not in this court's record, and there's no way for this court to know what was argued and what the circumstances were for granting that order. There is also another order denying a motion for rehearing on the issue of appellate attorney's fees, and again, the same problem arises as to that there's no way for the court to know what happened, what led to that order. Now, missing from all of this is what happened at the Florida Supreme Court in the 2009 case. Once that was appealed to the Florida Supreme Court, and the Florida Supreme Court decided not to take jurisdiction, the very last line of the order from the Florida Supreme Court, respondent's motion for attorney's fees is hereby denied. Now that the trial court has found that the policyholders were not forced to file suit, that should be the same result as to the 2009 appeal in this court, and in fact as to any appellate attorney's fees in the 2 appeals before the court today. The policyholders did not prevail in the trial court. They were not entitled to appellate attorney's fees, and the trial court should have given effect not just to the order, but also to the opinion to be in full compliance with the court's mandate. And if the court doesn't have any further questions, I'll just reserve my 5 minutes for rebuttal.
Anybody? All right, thank you.
Good morning again. I'm still Tom Elliott, still here for the Beverleys. There are two reasons. I'm going to address why their argument comes way too late and why it's wrong on the merits. But I would first observe that if the court were to determine from the prior appeal to look at this and say, you know, once State Farm had all this stuff, they didn't do anything, they litigated for 10 months, they could have paid, that shows that the suit was reasonable and needed. If you reverse for us on that one, that moots this appeal. Okay, so that's a bonus. If we win the first one, this one's moot. Okay, now, as to why they're wrong on this one. State Farm admits, if you look at page 10 of their initial brief, they admit the trial court followed the literal terms of the fee order. The fee order says, go award a fee to us. And I'll talk about why that is and why that's right in a minute. But they're way too late to raise that argument. To ask you now to go back and in 2014 or in 2013 when they filed this, to ask you to revisit a 2010 order because the term of the court from there has long since expired. And the State Farm, interestingly enough, versus judges of DCA's Florida Supreme Court opinion we cite, says you can't change a ruling after the term of the court. You just can't do it. Okay, so in their reply brief, they say, oh, well, but see, the mandate says this, and look at the mandate and the opinion together are 11 pages. The mandate's 1 page, the opinion's 10 pages. That's what they cite to in pages 5183 to 5193 of the brief, 11 pages. Fee order's not attached to that. Fee order is a separate order from this court. So even if their argument had any validity, which it doesn't because it comes way too late, it's simply wrong. The opinion addresses only trial court fees. It doesn't address appellate fees at all. It doesn't say the appellate fees are contingent on what you decide later on, and it doesn't. And there was a reason for that.
Well, but are you suggesting that the order from this court presupposed that fees should be ordered on a hearing that was yet to be had and the outcome unknown?
No, not at all, Your Honor.
I followed your argument.
No. The argument is we got an order for appellate fees because of what happened in the appeal, not what was going to happen in the trial court. The appellate fees, and let's turn to that because this is why the appellate fee order is correct, even if they could revisit it 4 years later, which they can't. We cite a number of cases. You don't have to recover money. You don't even have to get a declaration of coverage to be entitled to a fee from the insurance company. There are all kinds of situations, Beretta on appraisal, Pawtucket, Latin America. We cite all these cases. You get fees. You prevail against the insurance company on a discrete issue, you're going to get a fee. Okay? And I want to go through the policy language in a minute. But what happened here, and what was missing in Clifton, and what was missing in Hill, is here they made a fee motion in the appellate court seeking to tax fees against the Beverleys if the Beverleys had lost that prior appeal. And the same fee order that grants us fees denies State Farm's fee motion. State Farm will never, ever be able to get fees from the Beverleys for that first appeal. That's done. Without a mandate from this court, an order from this court, the trial court can't assess those fees. So they don't get those fees. When we won the appeal, we defeated State Farm's appellate fee claim. Trial court fee claim for us is still pending. We defeated their appellate fee claim.
And to follow up with Judge Moore, because that got a little confusing, Mr. Elliott. So this whole thing was that, call it appeal number 1. And appeal number 1, what the court awarded is your request for fees you were successful in handling that appeal based on the court's prior opinion. That's totally unclear.
I'm sorry, now I'm unclear on that.
Let me rephrase that.
Okay.
The fee issue here that you're addressing deals with the appellate fees that was awarded to you and that were denied to State Farm.
Correct.
All right.
So you're entitled to fees because you prevailed in getting the summary judgment reversed?
No, we're entitled to fees because we defeated State Farm's fee motion, which would have assessed fees against us. That's forever defeated. They can never come back. That was not subject of the remand. We're entitled to fees because they tried to get fees from us and they can never come back. And that's exactly what happened in Hamilton. And I'm happy to file the motions in Hamilton. I mean, I have to look at the case. I know it was different appellate counsel. I'm sure it was the same trial counsel, though, pretty sure. The same trial counsel you just heard from at the prior argument was the one who got the summary judgment in Hamilton, which has been reversed. They were seeking fees against Mr. Hamilton in the trial court, and when we got the summary judgment reversed it would have defeated their attempt to get fees from him. So we moved for fees. The court gave us an unconditional fee, appellate fee in Hamilton. The other side said, whoa, whoa, you shouldn't do that. We filed a response, and the court denies their rehearing. And I'm happy to file all those pleadings. It's got the same cases in it, for the most part, that are being argued to you today. So the Fifth District has ruled on this issue since the briefing in this, consistent with exactly what we're arguing here and exactly what this court did 4 years ago. Okay, so now what did we win 4 years ago? We did win the right to go back. Yes, Judge Sleet. That's still open on the table, and if we win that case, we'll get fees for the trial court effort in that case.
And I think what the confusing is appellate versus trial.
Yes, yes. This is only about appellate fees. This award is solely appellate fees from the first appeal, and in that first appeal, we defeated their request for fees against the Beverleys. And let's look at, I agree, we need to read the statute. 627.428(1). It starts off, upon rendition of a judgment or decree by any of the courts of the state against an insurer and in favor of an insured, okay? The fee order denying appellate fees to State Farm is a judgment or decree in our favor of the insured and against State Farm. Defeated their request for appellate fees. They will never get appellate fees from the first appeal. Done, period. Okay? Then the next language talks about under a policy or contract executed by the insurer. Clearly, when you read the grammar of that, that refers to the insured. It modifies insured, omnibus insured, or the named beneficiary that comes right before that. So that's not a problem for us. You don't, and the case law is very clear, you don't have to have established coverage, you don't have to have collected money to be entitled to a fee. You just have to get the decree against the insurance company, the judgment or decree. And go down to the bottom, no problem with that. The attorney prosecuting the suit in which the recovery is had. The recovery here was a recovery of a decree or judgment that defeated their claim for attorney's fees. Their claim for attorney's fees, I don't know how much it would have been, but it wouldn't have been a lot of money. So we defeated their claim. We prevailed on that in the prior appeal. So, when you read through the statute, this court's prior ruling was exactly correct. The Fifth District has done the same thing, and I'm happy to file those motions. If you want more information on that. I think you can probably pull them right offline, but I'm happy to file them. Again, it's too late to argue to you to change something 4 years later. The De La Fay case, there's no suggestion, first off, in that case, the Allstate De La Fay, there's no suggestion there was any fee motion by Allstate that they had made a fee motion against the insurers, and by the insurers winning on the appeal, they had prevailed on that. And if the De La Fay case, there's no evidence in that case, no suggestion in the opinion that anybody raised the mandate problem, the term of court problem, that they were trying to change this long afterwards. Obviously, the Third District cannot overrule the Florida Supreme Court. And the Florida Supreme Court has spoken very clearly to this in State Farm versus Judges.
Let me ask you a question, Mr. Scott, if I may. If State Farm did not file a request for fees, if that was off the table, and would the court have been correct in awarding you appellate attorney's fees?
I think at that point it would have been conditional. Most likely would have been conditional. Because we wouldn't have had a decree against them for anything. We prevailed on the decree against them for their effort to get attorney's fees. So by them being aggressive and trying to get fees from their insureds, they did subject themselves to this, yes.
Okay.
But that's fine, and that's the way you ruled 4 years ago. It's still correct today. It's the way this Fifth District ruled 3 months ago. The final point, they didn't preserve this argument. This argument, you got to read this together and so forth. They briefed this extensively. If you look back, you'll see they kept filing motion upon motion upon motion, trying to get the trial judge not to follow the literal terms of the order, as they admit it says. And nowhere in there do they say, well, Judge, you got to look at this and you got to look at that together. The quote they have from an oral argument that it defies reason. Saying something defies reason is not the same as saying you have to construe this and that together. So they haven't even preserved the argument they're making today. But it doesn't matter because it's wrong on the merits and it's too late. So for all those reasons, we would ask you to affirm. Unless there are any further questions?
Anybody?
Thank you.
Okay, thank you, Mr. Allagatt. Okay, Mr. Lugo?
May it please the court, I would like to address 3 points that my opposing counsel raised in his presentation. The first point, he relies or he cites a litany of cases that are in his brief and bullet points in his answer brief. They're bullet pointed in the reply brief for the proposition that a policyholder can recover attorney's fees even if there's no judgment, as long as there's some kind of recovery. Well, if the court reads those cases closely, in all of those cases, the recovery that was had was a recovery of some kind of right pursuant to the policy. That is not what happened here. And he's just conceded in his presentation that the entire basis for his argument is that the Beverleys successfully defeated a claim for appellate attorney's fees in the 2009 appeal based on the proposal for settlement statute, because that was the basis of State Farm's motion for appellate attorney's fees in the 2009 case. That is not, Section 768.79 is not a benefit under the insurance policy. It does not come under any of those cases bullet pointed in the answer brief or the reply brief. And I would also like to point out that all of those cases bullet pointed in those two briefs involved trial court fees. There was a recovery of benefits in the trial court as mandated by the statute. There has to be a recovery. They have to prevail in the trial court. The fact that they prevailed on appeal on an appellate fee issue under a separate statute is not enough, because they did not prevail in the trial court. The trial court ultimately found that this lawsuit was not necessary and it was only filed to perfect the right to attorney's fees and to file a subsequent lawsuit.
Did the calculation of fees that were ultimately awarded include the time spent in the evidentiary hearing on remand?
I don't know the answer to that question, Your Honor.
Isn't that kind of going to tell us a lot one way or the other?
Maybe, but under the statute, well, if that happened, it would be even clearer error, because they weren't entitled to.
Well, because if it didn't obviously include the fees that were generated in the evidentiary hearing on remand, then it was a court's intention to read the order from this court as saying, just calculate the fees on the appeal in which you weren't successful.
Okay, I guess your question is, did the court limit it to just the fees? And I guess it would be just the fees related to defending against State Farm motion for appellate attorney's fees under the proposal for settlement statute. And I don't think, I'm pretty sure it was not limited to that narrow issue. It was appellate attorney's fees in general, in toto, and that would be improper, even if this court were to follow the position advocated by opposing counsel, which is unprecedented in Florida law, to award appellate attorney's fees regardless of the outcome in the trial court. It would still be error, because the fees would not be limited to litigating the issue of appellate attorney's fees, defeating State Farm's motion for appellate attorney's fees. Now,
and Ms. Wick, I want you to also address one of the things that Mr. Elegant mentioned about the 5th DCA, that they did the same thing, that this court should be able to follow what the 5th DCA indicated.
Well, Your Honor, the order from the 5th DCA, it's tantamount to a PCA, because all it has is the ruling of the court. There is no explanation, there is no analysis to follow. Absent the motions, in some way to know what was, raised, preserved, or argued or decided by the court, those orders don't stand for anything other than the fact that they were entitled to fees in that particular appeal. And because that's from a separate DCA, this court can't take judicial notice of the motions in that case. Now, the third point I want to argue is this preservation issue. This was preserved going back to the 2009 appeal. When they filed the original motion for attorney's fees, the response said, deny it, the lawsuit was premature, was not necessary, 627428 is inapplicable, is worded and is applied by the case law, and it tied it to whatever the result was in the appeal itself. And then after the fee order came out, State Farm filed a motion for clarification. And in that motion, on page 9, State Farm asked for clarification, quote, as to whether the fee entitlement issue, as to which the panel has decided there are material fact issues, would generate entitlement to fees also for this appeal. Asking the court, are these two things interrelated? This court denied that motion for clarification. It was obvious that the two things had to be related. The mandate relates one to the other. And then the issue was trialed again, it was raised again on remand in response to the policyholder's motion for reconsideration for the court to reserve jurisdiction to consider the appellate fees. State Farm argued that the decision and the fee order had to be read together, and that this response is at record 35 in the 2012 appeal, page 6809. And then again, at the fee hearing, at the hearing on the amount of fees, State Farm renewed all the prior objections and again argued specifically the Allstate versus De La Fay case, the same case State Farm is asking this court to follow today. Not to recall, not to alter the mandate, but simply to clarify, as in De La Fay, that the appellate fee order was contingent to what happened on remand. If you're not entitled to fees in the trial court, you're not entitled to fees on appeal under 627-428. And if the court doesn't have any further questions, I'll conclude my presentation.
Very good, thank you. Okay. Well, the court's going to go ahead and take about a 10-minute recess, and then we'll be able to proceed with the next docket.